May 21, the court could not sit Jesus strike. That's why it is the judgment goes this on the 10th of October 2017. The claimant out a oral form of complaint accompanied by statement of facts, witness statement, list of witnesses, list and photocopies of document to be relied on trial. In the statement of facts, the claimant claims for the following reliefs. An order of this honorable court directing and security advisor, office of national security advisor, to immediately release the claimant's and other events from July 2017 further delay, from July 2017 determination of this case. To read an order of the court direct compelling the national security advisor and office of the national security advisor immediately release all household items, with television, gas, radio set, electric cooker, furniture, and all documents from unlawfully burgled and taken away from the residence on instruction of the former NSA. 3. An order of the Honorable Court awarding 10 million naira against the security advisor and the office of the National Security Advisor, being compensation for the detriment, losses, and damages suffered by the claimant. 4. And for such further or other orders as this honorable court may deem fit to make in the circumstances. The claimant, in proof of his claim, testified as CW1. He also called 2 other witnesses who testified as CW2 and CW3. They were his wife and cousin. All the witnesses, after identifying their respective witnesses' statement on oath, adopted same as their evidence in this case. Documents were tendered through CW1. They were admitted in evidence and marked as exhibit accordingly. Upon being served with the originating court processes, the defendant, with leave of court granted, have filed their statement of defense out of time. They also called 1 witness who testified as DW1. The witness, after identifying his witness statement on oath, adopted same as his evidence before the court. Thereafter, he was cross-examined and discharged. At the close of the defense, parties were ordered in line with the provision of Order 45 of the rules of this court to file their final written addresses. The evidence which the claimant relied in proof of his case is that he was a driver in the office of the National Security Advisor attached to one Mr. Ahmed Idris, the personal assistant domestic to the former National Security Advisor, Colonel Sembo Dasuki, retired. As a driver to Mr. Ahmed, he was responsible for driving him to various locations where arms deal loot were distributed throughout the tenure of Colonel Dasuki as the National Security Advisor. The claimant decided to expose the looting of the Nigerian treasury by the former National Security Advisor to support President Buhari's fight against corruption. The claimant stated that he was disgusted with the looting of National Treasury by the Office of the National Security Advisor, which prompted him to follow the issue. That it was out of patriotic zeal to save Nigeria from treasury loot that prompted the claimant to escape with 2 briefcases out of 6 briefcases, each containing about 550,000 United States dollars, which was in a lawful possession of Mr. Ahmed Idris, the personal assistant domestic to Colonel Dasuki, retired, on the 19th day of June 2015. The claimant handed over the money to his cousin, one Mr. Jerry, a staff of Code of Conduct Bureau, Abuja, with the instructions that he should hand over the money over to the chairman of the CCB in order to expose corruption. According to the claimant, he had previously informed his cousin of the looting, and he advised him to get evidence before he could make such grave allegations. The money contained in the 2 briefcases were later recovered by the Office of the NIS, by the Office of the National Security Advisor, who tracked the cousin's phone number to his residence. On the 19th day of June 2015, the Office of NSA ordered arrest of the claimant's wife. She was arrested, molested, brutalized, and forced to sleep at the Federal Secretariat Police Station alongside with her 4 children, including 6-month-old twins babies. On the 28th day of June 2015, the former National Security Advisor ordered his armed security men to invade the residence of the claimant at Wuse, where they broke into his house, made away with his official document, and carted away every property and household items belonging to the claimant. The former National Security Advisor ordered the Director of Finance and Administration to stop the claimant's salary without any formal termination. The claimant was not invited to face any panel, nor was he issued with any query. The claimant reported the matter to Code of Conduct Bureau, and he volunteered statement on the 9th day of July 2015. He was further invited by the Code of Conduct Bureau on the 16th day of October 2015 for further interrogation. In the defense of the defendants, it was stated that the claimant conspired with members of his family and one Jerry to steal a portion of money meant for security of the country. They converted the money stolen to their personal use. The story that the money was given to Jerry for safekeeping was concocted by the claimant to cover up his crime. From the 19th day of June 2015, when the claimant stole the money, up till the date, claimant has refused or neglected to come to the office to explain his story. The money was recovered at Kaduna, where the claimant and his cousin Jerry escaped with the money. The claimant and his cousin should have reported to ICPC or EFCC if they intend to expose corruption. The defendants denied arresting the claimant's wife and the children, nor detain them. It was stated that after the claimant had stolen money and same recovered, the claimant stopped going to work and has never reported back to the office, even after Colonel Dasuki retired, has been removed from office as National Security Advisor. The claimant could not be paid salary because he stopped going to work from 17th day of June 2015 till date. The claimant could not be invited nor questioned because the claimant was nowhere to be found to be issued with query or invited to face disciplinary action. All the story about Code of Conduct Bureau are concocted by the claimant to try to justify illegal action of stealing funds of the Office of the National Security Advisor. The claimant was not allocated or given any official quotas. It was not possible. Therefore, it was not possible to eject him from the non-existence official quotas. The defendant formulated a single issue for determination to which whether the claimant has successfully proved his case to be entitled to relief sought. In arguing the sole issue for determination, A party who wishes a court to enter judgment in his favor must adduce evidence to prove his case to be entitled to relief sought. The law is firmly settled that he who asserts must prove, and that the burden of proof lies on party who will fail if no evidence at all is adduced in the proceedings. In support of this view, counsel relied on sections 131, 132, 133, and 134 of the Evidence Act. It is the submission of counsel that the Evidence Act has placed the burden of proof on the claimant in this case, who has asserted that his salary, allowances, and other emoluments were unconstitutionally stopped, that his household items were seized or packed away, and that he is entitled to compensation and damages from the dependents in this matter. He has the burden to prove his claims. In support of this submission, counsel relied on the case of FUT Mina versus Olutayo, reported in 2018, 7 Nigerian Kulolo report, part 1617, page 176. Counsel further submitted that the claimant in this case has not shown how the stoppage of his salary by the DFA on the instruction of the National Security Advisor from the month of July 2015 is unconstitutional and illegal. It is in evidence that the claimant has admitted that since the 17th day of June 2015, he has never stepped his feet into the office. It means for the claimant who was employed as driver with the Office of National Security Advisor has not gone to work for a period of 5 years. It is submitted that it is unconscionable for the claimant who stopped going to work from June 2015 to turn around and allege that the stoppage of his salary is illegal and unconstitutional. Counsel posited that salary is money paid to an employee for work done. To buttress the point being made, counsel relied on Intel Nigeria Limited and others versus Basi, reported in 2011, LPELR 4326CA. Counsel submitted that the claimant who has not worked for the period of claim is not entitled to any salary. He referred to Keystone Bank CLC versus Apollo B. Citation cited. It is submitted that claimant has admitted not going to work as from 17th day of June 2015 by the section 030413 of the Public Service Rules. Absence from work without leave is serious misconduct which attract dismissal. Counsel contended as at now, the claimant has a disciplinary action for 5 years of absence from work. Counsel submitted also that he who comes to justice must do justice. He who comes to equity must come with clean hands. The claimant who deliberately refused to resume work at his office after incident of 17th day of June 2015, the claimant cannot be heard to complain of non-payment of salary. It is further submitted that the general rule of contract is that party in breach will not be allowed to benefit from the same contract. The claimant who has not performed his duty as a driver in the office of the defendant cannot be allowed to receive salary for work not done, irrespective of the fact that the claimant's appointment is not officially terminated yet. The claimant want to be collecting salary for doing nothing. Counsel submitted the claimant has failed to prove stoppage of his salary was illegal, and he has absented himself from work for 5 years. He is therefore not entitled to any payment. The theory being advanced that his life is in danger has not been proved by him. On the second relief, counsel submitted that claimant has not adduced any evidence to establish that his household properties, to which television, cooking gas, etc., were unlawfully burgled and taken away from the claimant's official residence. On the instruction of the National Security Advisor, the burden of establishing reliefs to lies solely on the claimant. Counsel, in support of this submission, refers to the case of CPC versus INEC and others. Citations supplied. There was no evidence to support that the former National Security Advisor on the 28th day of June 2015 ordered his armed security men to invade the official residence of the claimant at Wuse 2. Therefore, Relief 2 has not been proved by the claimant. According to counsel, the evidence could not support, the evidence adduced by the claimant could not support his claim as there are several unanswered questions, and with the unanswered questions, the court cannot rely on speculation to determine a matter in favor of a party. On the third relief, which is for award of 10 million naira compensation for detriment, losses, and damages suffered by the claimant, counsel submitted, like the first and second reliefs, the claimant has not been able to adduce evidence in proof of that relief. Damages are not awarded for mere asking. Evidence to establish the circumstances justifying the award must be adduced before the court can award damages. The claimant has not done that. Therefore, he cannot be granted any relief of damages as contained in Relief 3. Counsel referred to the case of Emagara versus Sterling Bank, reported in 2018 LPELR 45147 in support of his submission. Counsel asked the court to dismiss the claimant's case for failure to prove entitlements to the reliefs. The submission of the claimant submitted two issues for resolution. They are whether the claimant has proved his case to be entitled to reliefs sought. Two, whether the defendant is still an employee of the defendant and still entitled to his salary until retirement. In arguing issue 1, counsel for the claimant posited that the answer to this question is in the affirmative. In support of this position, counsel refers to Order 40, Rule 1 of the National Industrial Code Civil Procedure Rules 2017, which provides that subject to the rules, to this rule, any other enactment relating to evidence, any fact required to be proved at the trial of any action may be proved by witness deposition and oral examination of witnesses in open court. It is the submission of counsel that, in compliance with these rules of the court, claimant has proved his case, which by bringing 3 witnesses, including himself, who testified and tendered 9 documents in support of his case. It is the submission of counsel that in civil proceeding, all that is required of a party is to prove his case on balance of probabilities. whether a party proves his case or not well deserved or not, will depend on whether the legal evidence laid will, if not on the probation, if put on the proverbial scale, tilt in one way or the other. On this submission, reliance was placed on the case of Naga versus Registered Trustees Recreation Club, reported in 2004, FWLR, Part 190, page 1360. According to counsel to the claimant has successfully discharged the burden of proof placed on him by balance of probabilities, by showing to the court that he works the defendant. He tried to expose through the whistleblowing policy initiated by the government, and the defendant admitted stopping his salary by the boss he exposed. The claimant testified and tendered letters written to his employer and the legislative arm of government to come to his aid, but none tried to help him. The claimant never went to sleep on his right, but forces against him were bigger than him, a mere driver trying to do the right. It is the submission of counsel that the claimant was later paid 1 million naira by this government for exposing the corrupt act of his boss after the boss was suspended and charged to court. They cannot turn and deny him for running for his life when they refuse to provide him with protection. It is the submission of counsel that the burden of proof has shifted to the defendant by Section 137 of the Evidence Act. The burden of proof is not static. When a claimant has discharged the initial burden of proof, the existence of facts alleged by him, the burden of proof otherwise thereby shifted to the defendant. On this, counsel relied on the case of Alao versus Kure, reported in 2000, FWLR, Part 6, page 889, ratio 1. According to counsel, in the instant case, the defendant brought one witness, but instead of proving their case, decided to totally abandon their defense after the claimant completely proved his case, and the burden shifted to them. The witness has no connection information, took no part, and had no knowledge, or at any time was he aware of any of the part of facts in this suit, or is that he is an employee of the defendants. In fact, the witness worked in a different department with the claimant and cannot ascertain if the claimant comes to the office or not. During cross-examination of the defendant's sole witness, he admitted that he only became aware of the claimant's reason for absence through one of his boss during their morning briefings, when he was told that the claimant has abandoned his duty, and even the superior officer who told him had no direct knowledge of any in the suit. Counsel submitted that the witness statement is counsel relied in the case of Zaki versus Mayaki. The claimant now becomes unchallenged due to the absence of any evidence from the defendant to contradict or controvert the evidence already given by the claimant. Counsel urged the court to enter judgment in favor of the claimant. On the second issue, whether the defendant is still an employee of the defendant and still entitled to his salary, until retirement. It is the submission of counsel that the public service rules is clear on the discipline and dismissal of civil servants in the event they are suspected or to have committed an offense. No senior officer has the right to stop salary right away or suspend his subordinate without following the rules. Counsel refers to the relevant rules of the federal government public service rules. According to counsel, by the rules, an officer can only be dismissed in accordance with the above cited provisions of the public service rules. Counsel posited that the claimant asking for his salary and damages was not out of place and is absent without leave or reason before such a drastic action will be taken against him. But such opportunity was never given to the claimant. The employers quickly stopped his salary, refused to correct the wrong claimant. On this submission, counsel placed heavy reliance on public service rules 0413, which provides any officer who absent himself from duty or travel out from Nigeria without leave renders himself or herself liable to be dismissed from the service, and the onus shall rest on him to or her position of the full penalty. It is submitted by counsel that the claimant is still in employment of the defendant, desiring to be paid his salary. No query was ever given to the claimant, no notice of intention being to commence disciplinary action against him, and no termination letter was ever issued to the claimant or even deposited in his file. In the case of Iderima versus RSCSC, that is Rivers State Civil Service Commission, and the case of Olanian University of Lagos, the court stated thus: where an employee is protected by statute, such an employee does not hold office at the mercy of the employer. The employer has no right to terminate his employment or stop his salary at will without first complying with the conditions set down for his removal under the contract of service. Employment protected by statute is contract for special character, and this differentiates the contract of employment under public service from one under common law, where the appointment is a mere master and servant relationship. Counsel therefore submitted stoppage of his salary is illegal, null and void, and the claimant deserves his wages to be paid from him. In concluding his submissions, counsel asked the court to resolve this issue in favor of the claimant and order reinstating and order that the claimant be reinstated and grant all the press court decision. I have carefully read and considered all the processes filed by the parties, the evidence led, and the written submissions of counsel for the parties. The counsel for the defendants formulated a single issue for determination, while the counsel for the claimant submitted 2 issues for determination. However, having regard to the reliefs being sought by the claimant, the pleadings of the parties, the evidence of the witnesses for the parties who testified in support and against the claim before the court, the 3 issues formulated by the parties can be subsumed into a sole issue for resolution, to wit, whether the claimant has proved entitlement to any of the reliefs being sought from the court as per his statement of facts. The law is well settled that a claim is circumscribed by the relief sought from the court, and the duty of the party making such a claim is to plead only such facts and materials as are necessary to sustain the reliefs and adduce evidence to prove same. The claimant is only required to adduce such evidence as will support his case. See the case of Gabriel Atibi versus Cable Metal Nigeria Limited, reported in 2008, LPELR 591SC. A hard look at relief one, which being sought by the claimant, will clearly reveal that the claimant's claim being for an order of court directing immediate release of his salaries, allowances, and other household items, emoluments and entitlement from July 2015 to July 2017, and from July 2017 till the termination of this case, is a claim for special damages. The claim for salaries, allowances, emolument being monetary claim are in law considered or categorized to be claim for special damages, in which the claimant is required to specifically and specially plead same. He is also to strictly prove same to the satisfaction of the court. See the case of 7-Up Bottling Company, PLC versus Augustus. See also NNPC versus Kilifo Nigeria Limited. See also Ine Monde Inveti versus Unity Bank PLC. As a claim for special damages, the claimant will only be entitled to relief one if he shows an entitlement to it, and not he comes by, and this can be done by showing how he comes by the quantum of the sum he is claiming. Therefore, the claimant will succeed by adducing credible evidence in proving entitlement to his claim, and this is not done by mere oral evidence. In fact, the case of Joseph Akinola and others versus Lafarge Cement Company, WAFCO, Nigeria PLC, reported in 2015 LPLR, has cautioned that against reliance on oral evidence to prove special damages. The defendant have insisted that the claimant is not entitled to relief one because he has absconded from work for over a period of 5 years. It was also stated that the purported claim by the claimant that he is running away for his life is no justification. The defendant maintains that the claimant has not discharged the burden of proof imposed on him by law, as he who wants judgment to be given in his favor must prove existence of facts which he asserted. The claimant who has not rendered services, was employed to serve, cannot turn around to claim payment for services not rendered. For the claimant, he has discharged the burden of proof on balance of probability by showing that he works for the defendant. He tried to expose his boss through whistleblowing policy initiated by government, and defendants admitted stopping his salary by the boss he exposed. The claimant insisted that the burden of proof shifted on the defendant and failed to prove their defense, as the witness that testified that he became aware of the reason for the claimant's absence from his boss during their morning briefings, when he was told claimant had abandoned his duty first. According to the claimant, the evidence of the defendant's witnesses, the evidence of the defendant witness is hearsay. It should be countenanced. The claimant asked the court to accept the evidence of the claimant as unchallenged, uncontroverted, and stand admitted, and should be taken as true position. As pointed out earlier in this judgment, claim for special damages must be proved to the satisfaction of the court, and this can only happen by adducing credible evidence. The claimant insists that his evidence is unchallenged is not enough. More particularly, when the main claim of the claimant is poor declaration, in which the claimant has to rely on the strength of his case and not on the weakness of the defense. Not only that, evidence does not become credible simply because it is unchallenged. See the case of Akal Lanu versus Omo Karo, reported in 2003, 8 Nigerian Kilo Report, 48 to 21, page 19. I shall therefore treat this claim on the strength of the claim by the evidence adduced before the court. I shall make it very clear that there is nowhere the claimant is making claim for wrongful termination or dismissal from service. The claim is solely based on stoppage of his salary, the alleged cutting away of his household items, and compensation, 10 million naira for detriment, losses, and damages suffered by the claimant. There is no doubt that the salary of the defendant had been stopped. This is clear from the pleading and evidence as contained in the witness statement on oath and the oral testimony of the witnesses under cross-examination. Therefore, the claimant's reliance on public service rules that prescribe mode of dismissal from service is not appropriate in this case. For the simple reasons that the claimant claim is solely based on stoppage of salary and there was no challenge to dismissal or termination of appointment. The reason given by the defendant for the stoppage of the claimant's salary is that the claimant, following stealing of money from the office of the National Security Advisor by the claimant and recovery of the said money from his cousin, he stopped coming to office and even after the removal of the former National Security Advisor, whom he alleged has stopped his salary, he still refused and neglected or refused to appear to come to office. For the claimant, his story was that on 17th of June 2015, while performing his driving duties with one Mr. Ahmed Idris, PA domestic to former National Security Advisor, he took away 2 briefcases from 6 briefcases in the car. He was driving the PA to the former National Security Advisor, that he handed over the 2 briefcases containing each 550,000 US dollars, according to his cousin. According to the claimant, his action in taking away the money was to expose corruption based on federal government policy on whistleblowing. He also stated that he reported the matter to Code of Conduct. However, the defendant have insisted that the story told by the claimant regarding Code of Conduct Bureau was concocted in order to cover up his crime. The law is well settled that he who asserts has the onus of proof. It is when he has satisfactorily adduced evidence in support of his assertion that the burden of proof will shift to the defendants to adduce evidence in rebuttal or to establish the defense being put forward by the defendant. Where the claimant has failed to discharge the initial burden, there is no duty on the defendant to adduce any evidence in rebuttal of the claim. I must state that the claimant's story on his quest for exposing corruption based on federal government policy on whistleblowing was a hoax. It is was as at 17 when the claimant removed the 2 briefcases containing money which he handed over to his cousin, one Mr. Jerry. There was no policy put up by the federal government on whistleblowing. The federal government came up with the whistleblowing policy in 2016. In 2016 and not in 2015 when the claimant, when the incident that led to the stoppage of the claimant's salary took place. To support my finding on this issue of whistleblowing, I refer to an article by Onue Blum on whistleblowing policy and the fight against corruption in Nigeria. This article the title on whistleblowing policy and fight against corruption in Nigeria, implications for criminal justice and due process. This article can be accessed at Wikipedia website. The address has been given in the body of the judgment. As accessed on 27th day of June 2021 at 00:17 a.m. In the article, it was stated thus, I quote, in Nigeria, 2 bills on whistleblowing and protection of whistleblowers have been waiting to be passed into laws. In the midst of the long waited, on 21st day of December 2016, the federal government put in place a whistleblowing policy to encourage people to expose fraud in the public and private sectors. As at March 2017, the federal government is still urging the National Assembly to pass the bill. In view of the foregoing, I have no reason to disagree with the defendants that the story told by the claimant on issue of whistleblowing and Code of Conduct Bureau was concocted by him to cover up his misdeed and maybe to attract sympathy from the public. Furthermore, the purported report made by the claimant to the Code of Conduct Bureau was after the recovery of the funds from the keeper, Mr. Jerry, at his residence in Kaduna, where he was trailed by the security agent. If the claimant had really wanted to expose corruption, why remove the money? Why remove only certain portions of the money and not all? Also, if it is true that the claimant really meant to expose corruption, why did he took the money to Kefi, where he handed it over to Mr. Jerry, and who then took the money to Kaduna to his residence to hide? The mere fact that the money was taken to Kefi and handed over to his cousin, who in turn took the money to his house or residence in Kaduna, where it was recovered, clearly shows the extent of the working of the claimant's depraved mind and that of his colluder in the act. In view of the foregoing, I came to the inescapable conclusion that the claimant was never prompted by any zeal to expose corruption by his action in removing the 2 briefcases which he removed out of the 6. What is more abhorrent is that counsel giving evidence in address to the effect that the claimant was paid 1 million naira for exposing corruption. Against the former National Security Advisor, when there was no abatement in the pleadings to that effect. Address of counsel is never meant to introduce pleading or to give evidence on behalf of a party. No matter how brilliant address of counsel is, cannot take place of pleading or place of evidence. Counsel are enjoined always to base their addresses based on the case put forward by the parties and not on extraneous matters. The issue that the claimant has been paid 1 million naira is not an issue before the court, as there was no any pleading to that effect and there was no evidence adduced to that effect. In view of the state of pleadings and evidence before the court, I sanction the decision taken to stop the claimant's salary. It will be shaken away from the responsibility for the defendants to allow the claimant to continue to be drawing salary from taxpayers' money for services not rendered. The claimant has admitted before this court that he has not been going to work since 17th day of June for fear of his life. There is no evidence before the court during the pendency that he was under any threat. He wouldn't have been appearing before the court if actually he was under threat. The provisions of the public service rules relied on by the claimant are totally not applicable to this case, as there was no disciplinary action instituted or commenced against the claimant to warrant invoking those provisions of the public service rules. The case before the court is for claim for special damages simpliciter, assuming that the stoppage of the claimant's salary is unconstitutional or illegal. The claimant still has not been able to succeed in proving his case. For a party to be awarded any release by a court of law, that party must not only plead with particularity, but also prove by credible and convincing evidence that he is indeed entitled to the reliefs being sought. The reason being that for claim for special damages, the claimant is required to specifically and specially plead and particularize the claim. This claimant has not done that. The claimant has also not told the court how much is his salary, which would have given the court an insight as to the amount to be awarded. As things are now, the claim for salary and allowances or entitlement is vague and speculative, as there is no evidence on the quantum and how the quantum being claimed is arrived at. The situation is that of uncertainty. The court will not engage in a gamble. The failure of the claimant to state his claim for salary allowances and entitlement with specificity is fatal to his claim and has rendered the claim ungrantable. The reliefs pertaining to promotion, allowances, and entitlement be reliefs that are vague, uncertain, and lacking in particulars and proof by the evidence before the court. The claimant has failed in his duty and cannot be granted such indulgence and award. The Supreme Court was faced with a similar situation in the case of University of Jos versus Dr. MC Ikogoha, reported in 2013, 8th Nigerian Ukilolo Report, FAT 1360, page 478, where it was stated thus: the respondent sought an order directing the appellant to confirm him as a lecturer in the Department of Political Science of the University of Jos, with effect from 27th January 1995, with all his promotions, allowances, and entitlement. The respondent did not state with certainty what his allowances and entitlement were, and as how he earned his promotion from one grade to another grade and for which period. These vital facts are not backed by any evidence. All the reliefs regarding promotion, allowances, and entitlement were vague, uncertain, unascertainable, unlikely in particulars, and proved by evidence. All the reliefs pertaining to promotion, allowances, and entitlement being reliefs that were vague, uncertain, unlikely in particulars, and proved by evidence must fail. In view of the foregoing exposition of the law, I came to the conclusion that the claimant has failed to prove the entirety of his claim for release of salaries, allowances, and emoluments, as the claimant as the claim of the claimant lack factualization and not specially proved. See the case of Southern Aberdeen Company versus Agosto, NNPC Clipo Nigeria Limited, all Sufra, as the court has not been told in the pleading and evidence what the claimant's salary is upon which he lays his claim. There is no such pleading. The law is that pleading without evidence goes to no issue, and evidence without pleading also goes to no issue. See the case of Ifeta versus SPDC, reported in 2006, LPELR 1436 SC. See also the case of the Shell Petroleum Development Company of Nigeria versus Kwame Amba, reported in 1999, LPLR 3202 SC. I now turn to Relief 2, which is for an order of court directing compelling the defendant to immediately release all household properties, to wit, television, cooking gas, radio set, pressing iron, electric cooker, furniture, clothing, and all personal document belongings unlawfully burgled and taken away from the claimant's residence on the instruction of the former NSA. The claimant is by law under an obligation to adduce credible evidence in proof of this relief. The claimant claimed that his household items were unlawfully burgled and carted away on the instruction of former NSA. The claimant has not adduced any iota of evidence to establish that the former NSA did order his household items to be removed from his house or to be burgled or carted away. No such instructions was tendered or shown to the court. The claimant has not told this court how he got the information. Make matters worse, the claimant has not, by any credible evidence, established that he is the owner of any of the items that were said to have been burgled or carted away. The defendant, by denying ever instructing taking away of claimant's properties and denying ever allocating any official quotas to the claimant, have joined issues on this item. The claimant's failure to adduce concrete evidence has rendered the reliefs unproved and liable to be dismissed for lacking in merit. I dismiss same. On Relief 3, which is for sum of 10 million naira damages as compensation for detriment and damages suffered, this claim is an ancillary relief to reliefs number 1, which is the main relief, which means depend on grant of reliefs 1 and 2. However, this court having refused to grant reliefs 1 and 2, relief 3 must also fail. It is hereby refused for lack of proof. On the whole, I am not satisfied that the claimant has proved any of his reliefs, as he failed to adduce adequate, credible evidence in proof of his claim. The case of the claimant fails like a pack of cards, and same is hereby dismissed for lacking in merit. I make no order as to court. Judgment entered accordingly.
As the court pleases. My Lord, we are very grateful for the sound judgment just delivered. Thank my Lord for the industry waiting for the judgment. Thank you, my Lord.
You get copies of the judgment by next week, but you will have opportunity of accessing it online tomorrow. It will be online tomorrow. You can visit our website tomorrow to get the soft copy, but the hard copy will be available by next week.
Thank you, my Lord.
Yes, call the next case.
Suit number NICN/YF/07/2019 between Pana Uma Phillips versus Adamawa University Movie and 4 others.
Any appearance? Any appearance? Yola registrar, are you online? Yola station registrar, are you online? Any appearance for NICN/YL/07/2019, Mr. Fanahoma Phillips and Adamawa State University Movie and 4 others? Any appearance? This case is for judgment. The judgment of the court is ready. It goes like this. Although the judgment was slated to be delivered on the 6th day of May 2021, but court could not sit due to Justin strike. That's why it is being delivered today. The claimant commenced the suit by a general form of complaint dated 7th day of May 2019 and filed on the same date. The complaint is accompanied by statement of facts, witness statement on oath, list of witnesses, list of documents to be relied on at the trial, and photocopies of documents to be relied on. By the paragraph 25 of the statement of facts, the claimant is claiming for 8 reliefs against the defendant jointly and severally. The reliefs being claimed by the claimant are as follows. 1, a declaration that the non-payment or stoppage of the claimant's salary and other entitlement by the defendant is illegal, null, and void. 2, an order of this honorable court directing the defendant to immediately restore the claimant's salaries, allowances, and all other entitlement from the day of stoppage of his salaries and allowances to the date of judgment in this suit, and assign duties proportionate to his position. 3, an order of this honorable court directing the defendants to promote the claimant to the position of principal executive officer, unconscious, 992, which he would have had the claimant's salary and allowance not to be stopped. 4, an order of this honorable court directing the defendant to pay the claimant the sum of 3,653,591 naira 76 kobo, only being his cumulative salaries for 39 months at 93,681.84 kobo from March 2016 to May 2019, and payment of 93,681 naira 84 kobo only for months thereafter, or the equivalent of his salaries and allowances for the omitted and upon subsequent promotion. 5, an order of this honorable court directing defendant to pay the claimant the sum of 10 million naira as general damages for unlawful stoppage of the claimant's salary and allowances. 6, 10% interest on the claimant's salaries and other entitlement from March 2016 to May 2019. 7, 10% monthly interest on the judgment sum from the date of judgment in final liquidation. 8, 5 million naira as cost of filing and prosecuting of this suit. Upon being served with the originating summons on the first day of July 2019, the defendant filed joint statement of defense. The joint statement of defense was accompanied by witness statement on oath, list of witnesses, list of documents to be relied on at the trial, and photocopies of documents to be relied on at the trial. In proof of his case, the claimant on 13th day of November 2019 testified as CW1 after identifying his witness statement on oath of the 7th day of May 2019. CW1 adopted same as his evidence in this case. CW1 was then cross-examined by IA Barde Esquire, counsel for the defendant. In the absence of re-examination, CW1 was discharged. The defendants, in proving their defense, called 2 witnesses. The first to testify was one Mr. John Uranika, who testified as DW1. After identifying his witness statement on oath, adopted same as his evidence in this case. DW1 tendered documents in evidence, and they were admitted and marked as exhibit DW1A to DW1F. DW1 was cross-examined by Mr. Atheb, counsel for the claimant, at the end of which he was discharged. The second witness for the defense was one Sunday Kwale Kepas, who testified as DW2. DW2 tendered 2 documents which were admitted in evidence and marked as exhibit DW1A and DW1. DW1, after identifying his witness statement on oath, adopted same as his evidence in this case. Documents were tendered and were admitted in evidence as exhibits DW1A to DW1F. DW1 was cross-examined and thereafter was discharged. The main crux of the claimant's case, as can be gleaned from the statement of witnesses, a statement on oath, exhibit tendered, and oral testimony of the claimant before the court, is to the effect that the claimant was employed by the first defendant as an assistant executive officer account as per exhibit CW1A. The claimant was promoted to the post of higher executive officer. I will skip the facts, those facts that form part of the case of the defendant. and claimant and defendant, sorry. I go to the submissions of the counsel. The defendant formulated 2 issues for determination. They are: 1, whether or not parties to this suit are bound by the defendant's conditions of employment, rules and regulations contained in the claimant's letter of appointment, which the claimant accepted when he signed the letter of employment. 2, whether considering the facts and circumstances of this case and evidence laid at the trial, the claimant has established his claim to entitle him to reliefs against the defendant. The argument of counsel has been captured in the body of the judgment, so I need not to go over it. I now go to the submissions of the claimant. The claimant equally submitted 2 issues for resolution. They are: 1, whether the stoppage of salaries and the failure to assign duties and responsibilities to the claimant was done in accordance with the extant regulation governing condition of service for senior staff of the case defendant and the principle of fair hearing. 2, whether the claimant has proved his case based on the preponderance of evidence to be entitled to reliefs he seeks from the Honorable Court. The argument of counsel has been captured in the body of the judgment, so I will skip the argument. When counsel got copies of the judgment, they will be able to read the submissions. In concluding, the claimant urges the court to hold that the claimant has proved his case and his relief should be granted. Court decision: I have considered the processes filed in this suit, the evidence laid by the parties, the final addresses, as well as listening attentively to oral submissions of counsel in adumbration of their respective final written addresses filed in support of the case of their client. The defendant and the claimant both formulated 20 issues for resolution. The issues are almost saying the same thing, but in different tone. But having regard to the facts and evidence adduced before the court, it is my candid view that this case can be resolved on a single issue, to wit, whether the claimant has proved entitlement to any of the reliefs being sought before the court. The facts constituting the basis of complaint by the claimant in this suit are straightforward. They have been stated in the earlier part of this judgment, therefore they need not to be restated herein. Before proceeding with the resolution of the dispute as submitted to the court by the parties, I shall at this juncture state that the final written address and reply on point of law filed by the defendants are replete with mistakes, more particularly regarding the marking of exhibit, tendering, most of the exhibits referred to were not properly referred to, and some were remarked by the defendants on their own way, not minding the marking given to the exhibit by the court. There are also other typographical and spelling mistakes. I shall point out here that counsel are expected to be circumspect whenever preparing court processes, as not paying attention to document means filing before There is even a document which was not before the court but was marked as exhibit, and reference was made to it in the address. It is also pertinent to state that the reply on point of law was substantially the argument of the already canvassed position of the defendant. The law is well settled that reply on point of law should only be filed to address new issues that were raised, which were not originally raised by the address being replied. This means that the reply should be restricted to new issues that were raised by the address to which the reply is being made. Reply address is also never meant to provide avenue for establishment of the salary of the already filed address before the court. Coming to the determination of the main claim of the claimant, it has been established by a long line of decided cases that burden of proof in civil cases rests always on he who asserts. Therefore, the burden is on the claimant in the instant case to prove that he is entitled to be paid his salaries and allowances, promotion, assigned duties, and entitlement of general damages. It is when the claimant has adduced sufficient cogent credible evidence establishing his claim that the burden shifts to the other party. This is because the burden in civil cases or matters is not static and may shift in the course of proceeding. In a case, depending on the state of pleadings at various stages, the initial evidential burden of introducing evidence to provide a claim to a legal right or liability based on the assertions of facts upon which right or liability is claimed is placed on the claimant, and until it is satisfactorily discharged on the balance of probabilities or preponderance of evidence as required under Section 134 of the Evidence Act, it should be noted that pursuant to Section 133, therefore, the claimant bore the initial evidential burden of proving the fact asserted on which he based his claim, if judgment is to be entered in his favor. See Adegoke versus Adibi, see also Agu versus Inaji, and a host of other cases cited therein. What emerges from the above cited cases is that burden of proof in civil cases is of two types. The first, which is termed legal burden, is the ability of a claimant asserting positively to establish and prove the entire reasonable portions of the case before a court of law. Can we give judgment in it that can give judgment in his favor? This is always constantly on the claimant. The other type is related to particular facts or issues which a party claims exist. It is this burden of proof that oscillate from one party to the other, while the first type of burden of proof is called legal burden or the burden establishing a case. The second one is not. From reliefs 8 being sought by the claimant, from the 8 reliefs being sought by the claimant, the first relief is for declaration that the stoppage of his salary is null and void. The second, restoration of his salary. The third is for promotion to the rank of principal executive officer. The fourth is for payment of salaries from March 2016 to the day of judgment. and subsequently till the 5th of to payment of 10 million naira damages for stoppage of salary. Cost of prosecuting of this case. All the reliefs being sought by the claimant in this suit are reliefs that fall within what is called in the law called special damages claim, in which case the law requires the claims to be specially and specifically proved. Where a party claims special damages, the burden is on him to prove the special damage by leading credible evidence, most of the times by document, which shows the actual loss suffered by the party. Furthermore, unchallenged if she digs it, evidence is not enough to prove special damages, where claim is required to be proved by documentary evidence. See the case of ATE and Co. Limited versus military governor Ogun State. See also UBN versus Wanko, reported in 2019, Siri Nigerian Law Report, part 1660. This means that special damages are such as the law would not infer from the nature of the act because they are exceptional in their character and must be claimed specially and proved strictly. The Supreme Court has provided guidance as to what strict proof means when it comes to use of proof of special damages. This was in the case of Onyiro versus Onyiro. I shall now consider the reliefs sought by the claimant vis-a-vis evidence adduced before the court, so as to see whether claimant has justified granting of any of the reliefs being sought. The law has been by a plethora of judicial decision that the claimant before the court, the claim before the court are circumscribed by the relief sought, and that the claimant duty is to lead material facts as would establish the law is that the claim before the court are circumscribed by the reliefs. See the case of RTB versus Cable Metal Nigeria Limited. Going by the reliefs 1, 2, 3, the claimant is praying for declaration that the stoppage of his salary is illegal, null and void, restoring the stoppage of salaries and payment of his salaries from March 2016 to date of judgment, and substantially that the claimant was employed by the first defendant as an assistant executive officer account as per exhibit CW1C122. The claimant was promoted to post of higher executive officer and designated cashier of the first defendant, the position which the claimant claimed to have held till date of filing The claimant was promoted to the post of higher executive officer account and designated cashier of the first defendant, the position which the claimant claimed to have held till date of filing this suit. The claimant stated that his job came under threat in 2015 when the second defendant and the then BASA of the first defendant were having personality clash. The claimant about that despite being diligent in performing his duties The claimant stated that his job came under stress in 2015 when the dependent and the Zen Basa are having personality clash. The claimant about, despite being diligent in performing his function as cashier for no just cause, the first dependent without any formal notice in the nature of query, suspended or even terminated appointment of the claimant abruptly, stopped paying his salaries and allowances. In March of 2016, the claimant stated that upon stoppage of his salary, he appealed for restoration of his salary, both orally and in writing. The defendant, on their part, stated that the claimant is not diligent to his duties as he has received from 2015 to 2016 5 queries. It was stated that in 2016, the claimant refused to obey internal posting when he was moved from cash office to budget unit. The claimant refused to report to his new duty post and also refused to hand over his previous responsibilities to Sunday Kuala Kepas. Consequent upon refusal of the claimant to report for duty, another query was issued to him. The claimant never made appeals through proper channel as required by the rules and conditions of service. In reply to the joint statement of defense, the claimant denied that it has been the claimant about that he has never absented himself from work under the period under review, but assuming he was, it could be those times that he was going to ICPC in Abuja and EFCC in Gombe for questioning, leading to filing of charges against him at Federal High Court, which were later dropped. The claimant stated that he was never issued with any query, nor was he represented by any wrongdoing. From the parties and evidence adduced in this suit, the bone of contention is legality or otherwise of stoppage of salary. I refuse to pay him. See Exhibit CWD. Letter dated 2nd May 2016, addressed to the Chairman Governing Council of the University. It is interesting to note that the Chairman of the Governing Council of the first dependent called for comment on the suspension of the claimant. For the dependent on their part, they stated that the claimant was not diligent as he was queried. The claimant responded to the response of the defendants, and he advised that he stopped going to work when he discovered that his salary had been invitation by EFCC and ICPC. In support of the response, the claimant relied on Exhibit CW1A and CW1B. The law describes that the relationship between employer and employee is generally to be found in the service agreement or letter of employment See Interdrilling Company Limited versus Ajijola. See also Anaja versus UBA. It is settled law, right and obligation and liabilities of parties to a contract of employment are to be determined on the basis of the terms and the conditions of service. CSSO versus In addition, the law does not permit the court to alter by subtraction or addition or to rewrite the terms of the contract. See all Niboye Technical Services Limited versus UBN Limited. See also Mazin Engineering and a host of other cases cited therein. The right, entitlements, and obligation of the parties in a contract of employment relationship are law and equity to be and are governed by the terms and conditions of voluntarily agreed by the parties and not by sentimental conjecture of what is fair or unfair conduct in relation to complete disregard of the terms and conditions. In the case of at hand, invited to appear or to write by any disciplinary panel or committee or any misconduct. In fact, the claimant vehemently denied being ever served with any query, which the defendant purported to have served the claimant. The claimant has equally denied ever being served with Exhibit DW1A, internal posting dated 4/3/2016, wherein it was directed that the claimant shall hand over a report to his new duty post on or before 9th of March 2016. The defendant seems to have dismissed with a wave of hand. The claimant's insistence on lack of service on him of the 5 queries said to have been issued against him for refusing to report at his duty post and absenteeism. The defendants have argued that there is no standard way to serve and the argument of the defendant on issue of service of query on the claimant seems to have been based on lack of proper appreciation of the service the service of query to an employee accused of misconduct is sine qua non for commencement of initiation of disciplinary proceeding that may lead to imposition of punishment on employee. Therefore, there must be proof of service for validity of initiating of disciplinary proceeding, more particularly for an employee that his employment is governed by statute, the law establishing the university, and regulation made thereunder. The importance of service of query cannot be overemphasized, as failure to lack of service will be fatal to whatever decisions that is going to be arrived at. See the case of Dr. Bayan versus University of Ilorin, where the Supreme Court insisted on the service of the originating summons on the defendant. The defendant's attempt the defendants in attempt to prove service on a 600 ledger reference WF420 incoming mail register of 2015/2016. Exhibit DW1B124 is a document of 4 pages comprising of cover page and there are other copies which contain columns. The first page with columns stated with 30th March 2016, then 31st March 2016, and 7th day of April 2016. While on the second page of exhibit DW1B124, the dates were not legible as in the process of photocopying. Some part of the page were not photocopied. I have observed that in exhibit DW124, it is to be noted that the notebook of 60 ledger, but only 4 pages were certified as certified to copy. This court was not told what happened to the remaining This court was not told what happened to the remaining pages of the document. This means that exhibit DW1B is an incomplete of the said document. The evidential value was further weakened by the fact that some part of the page were not properly photocopied. This means the court will not be in a position to sanction the certification made to show that it is true copy. In view of the foregoing, I will accordingly discountenance exhibit CW1B124 for not having any evidential value before the court. The fact that being an incompetent document has rendered the document suspect in its authenticity and probative value. Some decided cases have been provided therein. It is also my view that even if exhibit CW1B is giving evidential value, it is not capable of proving service on the claimant. I assiduously examined exhibit DW1B124 and the name of the claimant appeared in the purported incoming register on 31st day of March 2019 with the document received as per the register, but there was no It is also clear from Exhibit DW1B that there was no evidence to indicate that those documents were actually received, as the column for signature was blank. Likewise, the register of 15th day of March, in the third column, it was stated query, the column to indicate the said query was received was blank. This means that there is no certainty that the query was ever received by anybody. In the second page, the name of claimant appeared in the register, and in the second page, the name of the claimant appeared in the register, and the document said to have been received was the request, and document was said to have been received by budget. This clearly shows that something is amiss. The reason being that the claimant was being accused of refusing to hand over a report to his new duty post. I resume to new duty post. So if it is report, then why sending it where the defendant knows that the claimant was not there? It is clear from the foregoing that there was nothing to indicate that the claimant did receive the queries or document recorded in the register. Therefore, this has given credence to the claimant's claim that he was never served with any query. Furthermore, it was 5 queries that were served with the evidence before the court. I have no doubt in my mind that the claimant was never served with any query or letter of internal posting. With lack of service on part of the claimant, how then can the defendant expect the claimant to respond to what has not been brought to his attention? I am now inclined to agree that the whole process leading to stoppage of claimant's salary was a hoax. It was premeditated. If not, why should the exhibit be issued, BWB, be issued to the claimant on 9th day of March 2016, when exhibit DW1A clearly shows unambiguously stated that the claimant is to report on or before 9th of If not, why should exhibit be issued to the claimant on 9th day? Exhibit DWB be issued to the claimant on 9th of March 2016, when exhibit DW1A clearly in unambiguous term has stated that the claimant is to report on or before 9th of March 2016. By issuing exhibit DWD on 9th of March 2016, when the date for resumption has not elapsed, says a lot. It means the posting was not genuinely made. If it was genuinely made, the query for not reporting should have been issued after the expiration of the date for reporting. This means the defendant issued both exhibits this alone is enough to nullify the stoppage of the claimant's salary. The defendant have also heavily relied on item 4 of Part 7 of the regulation of the condition of service for senior staff, Exhibit DWF, as the basis of stopping the claimant's salary. I have perused the said provisions, and it is clear to me that the provision can be invoked by the defendant where an employee absented himself from duty without any genuine reason. The defendants have insisted that the claimant absented himself without permission to take advantage of special leave or take account. The claimant has averred that he was invited by EFCC and ICPC to Gombe and Abuja respectively in respect of allegations of stealing of property belonging to the first defendant. The defendants have argued that the claimant was on a frolic of his own by honoring invitation of the EFCC and ICPC. This is a stand taken too far by the defendant. I do not share the view of the counsel for the defendant that the claimant, by attending to invitation of EFCC and ICPC, was on a frolic of his own. I wish to point out that EFCC and ICPC were statutory organizations established by law. Wherein they were close with power of investigation of any allegations of crime bordering on money laundering, corruption, and other related offenses. The laws establishing the two organizations have also made honoring their invitation mandatory. This means that the claimant, by honoring the invitation of the two organizations, was not on a frolic of his own. The claimant has, in his evidence under cross-examination, maintained that his superiors in the office were aware of his attending of his invitation. I believe the testimony of the claimant that the defendants cannot claim ignorance of the investigation by EFCC and ICPC. This is because the charge Exhibit CW1A 1 to 11 and Exhibit CW1B are very clear. The property involved, which are the subject matter of the charges, belongs to first defendant, and from the proof of evidence attached to the charges, some of the witnesses penciled down to testify in proof of the charge as staffers of the first defendant. The counsel for the defendant has argued parties have mutually agreed to be bound by letter of employment and regulation governing the service, and that the claimant had agreed to be deployed to any department. In support of the argument that the claimant had agreed to be deployed to any department, reliance was placed on paragraph 3B of Exhibit CW1 6. Which provide, as long as you remain in service of the university, you will be liable to be employed in any department where your qualification and experience can be used, and you will be subject to the university rule and regulation in force. I have compared the above provisions of paragraph 3B of Exhibit CW1C1 to 2, which is correct reference, and found it to be same with the provision quoted therein. I have carefully and painstakingly, time without number, examined the provisions of paragraph 3B of Exhibit CW12 quoted above, and I cannot find therein a word deploy, which the counsel argued was what the parties agreed in the said provision. The word argued, the word used wherein the word used therein is employment, is employed, which I have underlined for emphasis. Employed and deployed are two distinct words which do not mean the same and the same thing, which do not mean one and the same thing. In the circumstances and in view of the clear and unambiguous word employed used therein, the parties have not by the said paragraphs agreed to deploy, but they have agreed that claimant can be employed in any department. In any department. And if the makers of Exhibit CW1C 122 wanted to use the word deploy, they would have said it and will not have stated deploy, will not have stated employed. In the circumstance, the only option open is to amend the subsisting deploy with employed. Alas, that has not been done. Nothing notwithstanding the absence of clear provisions on deployment, an employer has unfettered right to deploy his staff to any department to work, insofar as his work is relevant to the need of the department. Where an employee is deployed to any relevant department, he has no option than to comply with the directives. However, in the case at hand, there was no proof that the claimant has been informed of the posting but refused to comply. The claimant has insisted in his pleadings The claimant has insisted in his pleading and evidence on oath that under cross-examination that he was never served with the purported posting. As pointed out earlier in this judgment, the defendants have failed to establish service on the claimants of the queries and the posting letter. In fact, the query issued on absenteeism has exposed the hidden agenda behind the purported posting a query expose the hidden agenda behind the purported posting of the claimant. And issuance of queries. To my mind, the whole exercise was a hoax. It was a sham to victimize the claimant due to power play. Therefore, the claimant's purported posting was not based on paragraph 3B of Exhibit CW122 as being claimed by the defendant. It is equally my finding that the stoppage of salary was not in line with item 3.1B6 part of the regulation governing service of senior staff, Exhibit DWF. There is no disputing the fact that salary can be forfeited if absence was without good excuse. It has been seen that claimant was not served with any of the purported queries to warrant taking of such an action. To stop Furthermore, the employee had the written letter of request for restoration of his salaries and complaining that he had not been queried or asked to face any disciplinary action, and there was no response to it by the defendants. It is also my finding that the claimant has shown good excuse that may have, but he has, but such can only be when it has been shown that there is no good excuse from the claimant. It cannot be also be evidence of disciplinary process when no such process has been put in place by the proper organ saddled with the responsibility of taking such disciplinary process. On promotion, the law is well settled that promotion is not automatic or for mere asking an employee I have carefully perused the scheme of service exhibit CW1F. Promotion is not automatic. It depends on fulfillment of certain conditions, which include assessment and recommendation. And therefore, without evidence of or evidence showing entitlement to promotion, the claimants will not be granted relief for promotion. DW1 has stated that he acted as a registrar and has issued queries to claimant. The queries exhibit DWA, DWE were very clear. They were signed by John Urani, Kepas, and AR establishment for registrar. It is clear the signing DW2 stated that he never who relieved claimant who was moved to budget, and he also stated claimant never handed over. DW2 was economical to what actually transpired, as he had not told the court the whole story. Looking at the totality of the evidence adduced, the queries issued to the claimant were issued between 2015 to 30th March 2016. From 30th March 2016, when the last query was issued, to the claimant on 7th day of May 2017, when this suit was filed, is a period of 1 year, 1 month. What this means is that if it is true the defendant intend to discipline the claimant, why wait till this period without concluding the purported disciplinary action, or even take substantial step to carry out the disciplinary action appropriate to the infraction commenced the delay in not taking concrete steps to discipline the claimant within the ambit of the rules clearly shows that defendants are no longer interested in pressing for taking disciplinary action against the claimant. This means also that the defendant have condoned the alleged violation committed by the claimant. On the whole, I find merit in the claimant case, and I hereby make the following orders. They are: 1, the defendant shall immediately allow the claimant resume work as higher executive officer and assign him appropriate duties commensurate with his position in any of the department of the defendants where his services will be needed. 2, the defendants shall pay claimants' salaries from the month of March for the months of March and April 2016. This is because from his evidence before the court, he stopped coming to work about a month after stoppage of his salaries. The allegation, the salaries was stopped on 30th March 2020. The allegation labels against the claimant contained in Exhibit DWA to DWE are hereby set aside as those exhibits were never served on the claimant, and the defendant have by their procrastination in taking disciplinary action in respect thereof condone the alleged violations. The defendants shall pay the claimant the sum of 500,000 naira cost of this suit. I did not order payment of salary from May to date because the claimant has not been going to work for those periods. All monetary aspects of this judgment shall be settled within 21 days from the date of this judgment, that is from today, failing which 10% interest per annum shall apply. Judgment entered accordingly. Call the next case.
Suit number NICN ABJ 03/2018 between Okoro Ikeme Joseph and Major Investment.
Yes, any appearance? Any appearance? Any appearance in NIC stroke 8K stroke 03 stroke 20? Any appearance for NICN stroke ABJ stroke 03 stroke 2018 Okoro Ikemakolom Josephat versus Ledger Investment Capital Limited. Any appearance? Let me see your diary. This one, is it not the one they file terms of settlement? Yeah, I have not seen the terms of settlement. Where is it? I gave you some document today to bring, and they are back. No, it's not here.
Something like this. Yeah, I think it's this one. Something like this.
There is terms of settlement. Apart from this one, there is terms of settlement. Okay, it's here. This, I think. This case is adjourned to 7th of October for adoption. Take. Call the next case.
NICN ABJ 109/2018 between Usman, Musa Usman versus Wingard Nigeria Limited.
Appearance, any appearance? Any appearance, NICN, stroke ABJ, stroke 109, stroke 2018. Any appearance? This case is adjourned to 7th of October 2021 for adoption. Call the next case.
Number NICN /ABJ/110/2018 between Alamodu Adebayo Victor versus God is Good Motors, Nigeria Limited.
Any appearance? NICN stroke ABJ stroke 110 stroke 2018. Alamodun Adebayo Victor versus God is Good Motors, Nigeria Limited. Any appearance? This case is adjourned to 7th of October 2021 for adoption. Call the next case.
Case number NICN YL 21/2019 between Honorable Ismaila Lawadi and 22 others versus 1. Adamawa State Government, 2. Attorney General Adamawa State, 3. Ministry for Local Government and Chieftaincy Affairs, 4. Municipal Local Government.
Appearance, any appearance? NICN stroke YL stroke 21 stroke 2019. Honorable Ismail Alawandi and 22 others versus Adamawa State Government and 3 others. Appearance? This case is adjourned to 7th of October 2021 for continuation of hearing. Call the next case. That asset is not for today.
Yes, for tomorrow, my lord.
Okay. Thank you, counsel, who have been online. We have come to the end of today's proceedings, virtual proceedings.
Sorry, my lord.
Yes,
Sorry, my lord. Abubakar Saad. I was given a hearing notice in respect of Isa Bello against United Bank of Africa, my lord, for adoption, and I have not heard the matter in color.
he said there is Isabella, you serve him. Eh?
Okay.
My lord.
Sorry, counsel, it's for tomorrow, not today.
Okay, my lord. Okay,
Bello is
my lord.
tomorrow.
Ascot, please, my lord.
Sorry for keeping you waiting. I
No
didn't know
problem.
that up somewhere.
My lord, we have enjoyed the judgments.
Okay,
So
you are
it's all
welcome.
Thank you very much,
Yeah.
my lord.
You are welcome.
Thank you, sir.
Thank you. Okay. Administrator, you can discontinue with the sitting, virtual sitting.
Ascot, please. That's my right, young man. Allow
Okay.
judge Mr.
Okay.
So. Checking and mail of the registrar.
Chico,